I want to talk about why you want to avoid probate. Well, family members, when money is involved, can suddenly become very different than they were when you were alive. I've had family members, I have had this case. I had a woman who left everything to her partner. She was a teacher. Her family members came in and they said she wasn't gay. This isn't her will. You know, they challenged everything. We had to get the attorney in who drafted it to testify. Yes, she was of sound mind, and they fought it tooth and nail. So with gay couples in this surrogates court, which is one of the more progressive surrogates courts, there's still a presumption of what's called undue influence. So in my wills, I like to, and I'll talk about this, leave a paper trail, so to speak. I like to leave special language saying we've been together and it's my intention to benefit this person over my blood relatives. I like to have the power of attorney, healthcare proxy, disposition of remains, everything consistent so that the executor is the same person who's been appointed in all those other documents. And we can challenge those presumptions of undue influence if a family member comes in and challenges the testamentary plans in the surrogates court. The other two issues we talked about, it takes a long time, okay, and it costs a lot. Yes?
Can any family member, third cousin, twice removed, become an challenge?
Somebody has to have what's called standing to challenge a will. So the issue is, can anybody come in and challenge a will? If they're the only surviving relative, then yes. But generally, we're talking about one step away. So we go up to parents. Parents are deceased, we go to brothers and sisters. If they're deceased, we go to uncles. If they're deceased, cousins, etc. There are children, yes, children obviously are always in there. Interesting note, spouses always have a right of election as well. So you can't disinherit your spouse in New York State. They're entitled to minimum $50,000 or 1/3 if you're going through the probate process. And yeah, it costs a lot. I've seen some attorney's fees on probates that have made my jaw drop. And I want to say, how do you get that? Well, I can tell you how they get those fees. They charge a percentage. They don't charge for the hourly work. They charge a percentage. And the probate court is a cordial and friendly place. The judge reviews all fees, but more often than not, the surrogate judge will usually grant the fees if they're not excessive. And it really depends on the estate, the complexity, etc. But it does cost, it costs more than executing a revocable trust ahead of time or sitting down with your financial planner and making sure your beneficiary designations are all sorted out. So we have techniques to avoid probate. Revocable living trusts, which you may or may not have heard of, which are wonderful techniques, especially if there's complex property, property out of state, or you have an interesting disposition plan, a bunch of different people, and you want to, say, leave a trust for your spouse, and a trust for your kids, and a trust for your dog. We have beneficiary designations. So almost all the assets we own today, our 401k or IRA, our life insurance, many bank accounts, CDs, investments, can all pass outside of probate by beneficiary designation. But a lot of people just don't execute that form. They execute it wrong, or they do execute it and they leave it to who they want, but maybe they don't do a backup and that person's dead. So then we have issues.
You mentioned transfer on death.
Transfer, yes, transfer on death is included. The question is, I didn't mention transfer on death. Transfer on death is included with bank accounts, referred to as a Totten trust, allows assets to pass upon death. We have life insurance, which is one of my favorite tools to use, because if done properly, you can not only avoid probate, life insurance during your lifetime is income tax free, and on your death, it might be estate tax free. Now, you'll talk to a lot of insurance planners who will say it's estate tax free. What they don't tell you is that if you have to remove the indicia of your ownership from it. You have to set up an irrevocable life insurance trust or have someone else own it. So it's not automatic. The last way I like to avoid probate is joint ownership of assets. So again, it's a double-edged sword, because if you own it joint, you're considered to have 100% of the access to the asset. But if you own it joint and your partner dies, then you inherit 100% out of probate immediately. So you don't have to wait around. You don't even have to administer a trust. You just passes the next day if you show the death certificate.